Usually family law cases includes divorce or a child custody case. That's really emotional for really any family. Essentially, in family law cases, the judge will have to determine, all of your property, who gets more time with the children. Those are important things to people, so making it really, really hard for them to navigate through this process. We handle what's called pre-decree services, such as divorce, child custody. Those are things that we handle. We also handle what's called post-decree services, where after the judge has issued a divorce decree, we can, with contempt and some other issues, we handle those as well. I think the most common mistakes in divorce process is people who don't get an attorney early on in the game, because these are really challenging things to go through, and they are very difficult things to navigate in a case. So one of the most common mistakes I've seen for people who don't get an attorney is they don't know how to provide proper service on the other party, which is required by the court, and then it ended up with their claim being dismissed. So it is very important that people get an attorney as soon as possible. Yes, well, we come from a very compassionate approach. Our clients' priorities is number one for us. So just from the get-go, the minute we meet with the client, we ask them about their priorities, and then we put that at the forefront as we continue to work on their case. My approach is that we always try to come to an agreement on some things just to save some time for everyone involved. However, if it's a high conflict case where the parties disagree on everything, we do not hesitate to fight for our client. In the state of Colorado, if you are a parent, you have a natural right to parent. What that means is that you deserve parenting time with your child. You also deserve to make big decisions about your child, such as medical or academic issues. And you also have a right to child support if that becomes appropriate. Attorneys help with resolving conflicts. Sometimes because of all the emotions that are involved in a family law case, it is very hard to have a civil discussion with your ex-partner or your ex-husband or your ex-wife. The attorney is there to facilitate so we can come to an agreement on some issues. But on top of that, if there's no agreement, we are there to advocate for you in a clear, concise manner so the judge understands. I think Colorado has made quite a few changes, and which I think is good. The first, like I mentioned, is that all the parents have parenting time. Most judges prefer equal parenting time amongst the parties, which I think is wonderful because it's great for the development of the child. Absolutely. Some of our cases are pretty simple, but we do have some very high conflict cases where the mother and the father are very emotional about their child, which becomes very complicated because they do not come to an agreement on many things. However, we do our best to advocate for our clients' interests. In the custody of a minor, the first you start with is a petition for allocation of parental responsibility. There's also two other documents that you have to file into the court. They're called case information sheet and summons. You need to file into the court to start your case. After that, the judge usually requires mandatory financial disclosures that includes financial information about you, and you need to exchange it with the other party. And then the judge will require mediation, where you guys try to come to a resolution. If there is an agreement between you and the other party, then a parenting plan will be submitted to the judge. If not, the case will go to a final hearing. Of course, agreement is what we strive for. However, there are many instances where parties do not come to an agreement. What happens is that a permanent orders hearing takes place where both sides have an opportunity to present all the evidence they have as well as their argument in front of the judge, and the judge will make the final decision.